Hello viewers of Equinoxe Television, welcome to the program Unclassified Files. In today's edition, we are delving into the financial problems faced by MTN Cameroon and owned by the courts of first instance in Bononjo, here in Douala. It was after the Cameroonian billionaire Ahmadou Baba Danpullo filed a case in Cameroon. He is complaining that all his assets in South Africa worth billions of francs CFA have been confiscated by the First National Bank over unpaid loans. But MTN Cameroon and Tiger Brands insist that they have no direct financial relationship with the FNB Bank or Ahmadou Baba Danpullo. The center of all this discord is South Africa. So, Equinoxe Television was in South Africa to get concise and precise information about this whole saga. Baba Danpullo MTN FNB saga all began in September 2022 when the courts in Cameroon seized the mobile money account of the mobile telephone company MTN Cameroon worth about 133 billion francs CFA. MTN Cameroon is a subsidiary of the South African multinational, the MTN Group. Since the seizure of the accounts of MTN, the telecom company has been crying foul, as the funds which belong to MTN Momo subscribers are to be kept in a private account controlled by the court registrar of the Bononjo Court of First Instance. Another structure greatly concerned with the court's decision in Cameroon is the chocolate confectionery Cameroon Chococam, which is a subsidiary of Tiger Brands based in South Africa. The judges of the Bononjo Court of First Instance, following complaints by the Cameroonian billionaire, as well seized the accounts of Chococam worth some 5 billion francs CFA. The major curiosity stands: why have the accounts of MTN Cameroon and Chococam been confiscated by the courts of first instance in Bononjo Douala? Behind all the above crises is one person, Ahmadou Baba Danpullo. MTN Momo accounts were frozen following complaints filed by the Cameroonian business mogul. At the Bononjo Court of First Instance, the billionaire Danpullo complained to the court in Cameroon that his assets comprising real estate worth about 5 billion South African rands, an equivalent of about 250 billion francs CFA, have been confiscated in South Africa by the First National Bank, the FNB, a subsidiary of the parent First Rand Bank, in connection with a loan granted him by the FNB. The loan amounts to 22 billion francs CFA, which the bank accorded the South African-based conglomerate, the Barrister Company Limited of Baba Danpullo, some years back. The credit was to be paid within a period of 10 years, with an agreement of reimbursing 10 million South African rands monthly, which is about 400 million francs CFA. The seizure of MTN and Chococam accounts in Cameroon is in a bid to mount pressure for the bank to reinstate the property of Baba Danpullo. The lawyers of Danpullo also accuse South African authorities plus South African judicial system, whom according to them are backing the FNB Bank, drifting their blames on xenophobic tendencies on their client, who they think is considered a stranger in South Africa. And still on the reasons why Danpullo is taking on MTN and also Tiger Brands, Danpullo's lawyers, though not explicit enough, insist again that there exist indirect links between the FNB, Chococam and MTN. They explain the Public Investment Corporation PLC based in South Africa is a shareholder in MTN and Tiger Brands. The imbroglio for years now has been making headlines and threatening diplomatic relationship between Cameroon and South Africa. Now, several questions are still hanging in the air. First, what is the FNB saying about the accusations pushed forward by Danpullo's lawyers about the bank spoiling Barrister property? Credible sources tell us the loan has not fully been paid. Secondly, has all the property or assets of Danpullo been liquidated and sold out in South Africa? If not, which have been sold out and which are still under the control or ownership of the Barrister Company? Another question we will be answering in this investigation is, could it be valid that Danpullo's assets were seized and sold out in South Africa because of his skin color, or xenophobic tendencies as reported by other media outlets in Cameroon? And also, another question is, what is the official statement of other enterprises suffering from this tension? We are talking about MTN and Tiger Brands or Chococam. which arbitrations in South Africa have also heard the Danpullo FNB court case. Equinoxe Television took the giant step to travel to South Africa so as to get first-hand information on the genesis of the Danpullo FNB loan affair. We just arrived at the OL Tambo International Airport in Johannesburg, South Africa. Equinoxe Television is here to get first-hand information on the Barrister company, Transnational Bank credit or loan affair. We will be meeting with court officials and also the banks concerned. We will also talk with some companies dragged in the credit affair, such as the MTN Group and Tiger Brands. We are in South Africa to investigate on the judicial affair. Our first move was to get to know more on the South African judicial system and how the courts function. This led us to one of the courts on the outskirts of Johannesburg, the Randburg Magistrate Court, situated on the countryside, few kilometers away from Sandton City. It was a busy day here when we arrived. Right now we are at the Randburg Magistrate Court. Randburg is a city not far away from Johannesburg, all of them in the Gauteng province. We are here to speak with an attorney or the state prosecutor to tell us exactly how the South African judiciary is organized or structured and how the courts operate here in South Africa. We spoke with some attorneys on how the courts in South Africa are classified.
They have classified our courts into two parts: the lower courts and the higher courts. And then there are other specialized courts. The lower courts, there are you find the district magistrates courts, which deals with in terms of civil matters ranging with amounts claiming if you claim for an amount ranging from 0 to 200,000, you lodge it at the district magistrates court. And then if the money that you are claiming is from, for example, 200,000 or from 0 to 400,000, then you go to the regional magistrates court. And then there are also small claims courts, which are courts which deals with small matters. For example, if you want to claim in a civil court or in a civil matter, you want to claim an amount of 20,000, then your matter is going to be dealt with in the small claims court. All these three courts, your small claims court, your district magistrates court, and the regional court, you find them in the magisterial district. You find all these three courts. And then with the higher courts, you find the High Court, you find the Supreme Court of Appeal, you find the Constitutional Court. And then courts which are in the same level with the High Court, you find your labor appeal court, your labor court, your competition court. Those are regarded as being on an equal level with the High Court. And there are various divisions of the High Courts in South Africa. In each and every province, there are plus minus 2 divisions in each province.
Another major question we are seeking answers to in South Africa is, could the seizure of Danpullo's assets in South Africa be racially motivated? In our chat with lawyers here, they told us apartheid is a thing of the past and xenophobia is strictly condemned and punished by the laws in South Africa.
In South Africa, everyone is equal before the law. So it doesn't matter if you are the president or the minister, the law is going to be treated as if you are a layperson or you're not any different. We've got something in our criminal system called crimen injuria, which you can be arrested for any racial remarks. And there's no way that you can turn around the Constitution. The Constitution, I mean, South Africa does have the best Constitution in the world, or as it's been claimed, but you cannot go around that. The law is very clear in terms of our Constitution that no one is above the law.
One of our principal missions in South Africa is to speak one-to-one with the liquidators, in this case, Secheba Trust, which is the organ appointed or solicited by the court to take charge of the liquidation process of Baba Danpullo's assets. No better way than to get to the court, which have heard the case pitting the Besinve Company and the FNB Bank. Our next stop then was the Johannesburg High Court. We are here at the High Court of South Africa, Gauteng Local Division, Johannesburg. It is in this court that the Cameroonian business tycoon filing a complaint about some South African banks, the First National Bank inclusive, about his assets here in South Africa, which are already in the process of liquidation. We want to find out how far the court has gone with the case file and what way forward, and why not have access or lay hands to some of the documents in that case file. After discussions and negotiations with court registrars and other attorneys on the possibility of having any information on the case between Baba Danpullo and the FNB proved abortive here, we continued our investigations with Attorney Green Sekambe, a barrister at law specialized in civil law, contract, administrative and public law, and most especially estate administration. Attorney Green is deeply introduced into the South African judiciary. From his findings, he told us the case file had been dropped in Pretoria by Danpullo's lawyers. From Johannesburg to Pretoria, we must go by train. The journey took us about 30 minutes. For over 2 weeks, the Equinoxe team was in South Africa. We moved from one courtroom to another. Our legal source here told us that from the superficial documents he could lay hands on, there is a great possibility the case file was heard in Cape Town. The Equinoxe team poised to get precise and concise information on the assets of Baba Danpullo, which have been liquidated, and those not concerned in the loan saga. We immediately decided at dusk to travel down to Cape Town. Our intention was to get to Cape Town as early as 8 a.m., so we had to leave our hotel rooms at Sandton City even before dawn. At 4 a.m., we took off for the OR Tambo International Airport to board the first flight to Cape Town. It was a long flight, flying through sandy beaches as we aim for the seaside resort city. Finally, here we are in Cape Town. We headed directly for the High Court in Cape Town. Welcome to Cape Town, one of the biggest cities in South Africa. I am present in front of the High Court in Cape Town. Our close legal sources informs us that it is in this court that the case pitting the Cameroonian business moguls company, the Besinve, and the First National Bank has been heard. So we are pushing forward to get more information about that case file. Courageously, we made our way into the offices, all in search of the famous case file. We need to know the exact amount of the loan, which property has been seized, and what property is not concerned in the liquidation process. At the High Court, the attorneys we spoke with explained that it was prohibited to access a plaintiff's case file without their consent. But with their assistance, tact and directives from other collaborative attorneys, we finally laid hands on a liquidation document with a heavy sigh of relief. This is because the document contains much of the information we are in search for here in South Africa. These documents I have in hand is a case filed by the liquidators. In this case, Secheba Trust. It contains details on the assets of property already sold out, those still in the liquidation process, and also the net worth of those property. Let's get the details together. In this document, we got concrete information on the property of Baba Danpullo, which have been seized by the bank and have been in the liquidation process. The real estate properties concerned are located in Johannesburg, Cape Town, and Port Elizabeth. They include Princess Crossing, Northern Rose House, Hyde Park, and Constancia. The Equinoxe team wanted to know the exact location of this property and the magnitude and how much they can cost. Our first stop was at Northern Rose House, situated at 8 Riebeck Street in Cape Town. The gigantic structure behind me is called Northern Rose House. It is owned by the Cameroonian business mogul Alhaji Baba Danpullo, and just a stone throw from there is 1 Table Square. It is a structure of over 30 floors, also gigantic, owned still by the Cameroonian business mogul. But our legal sources here in South Africa told us that those 2 buildings no longer belong to him. This building is made up of over 100 high-end apartments plus other businesses. It is situated at the heart of Cape Town. Just beside Northern Rose House is another magnificent building which also serves as an attraction park for visitors. Like Northern Rose House, Table Square as well accommodates businesses and several high-end apartments. It is also very gigantic. We are not allowed to take pictures of the building because it is heavily guarded with serious security around. Those were the 2 properties owned by Baba Danpullo in Cape Town, but has been auctioned by the FNB Bank. We had to board our flight again back to base in Johannesburg. Following information from the liquidation case document or file, Princess Crossing and Hyde Park, all of them contained in the court document, are located in Johannesburg. While in Sandton City, we set out directly to locate their board. Next stop was at another vast property. It is Princess Crossing. Princess Crossing, another property which was owned by Cameroonian business mogul Alhaji Baba Danpullo. It is built on several hectares of land here in Rosaport and accommodates several companies. And our legal sources again here in South Africa tell us that Princess Crossing no longer belongs to the Best Inver company. It has been seized by some banks here in South Africa over unpaid loans by the Best Inver company. Some few kilometers away from Princess Crossing is another property which was owned by the Cameroonian billionaire Alhaji Baba Danpullo. It is the Hyde Park. This other huge building behind me is called the Hyde Park, situated here in Johannesburg. It consists of a supermarket, a hotel, and other big apartments. Before now, this building belonged to Best Inver company of Alhaji Baba Danpullo. But as it stands now, it no longer belongs to the Best Inver company. It has been confiscated by the FNB and other banks here in South Africa over unpaid loans. The Hyde Park is another very huge property which was owned by Alhaji Danpullo. It consists also of a large supermarket, several high-ended residences, and even a TV station. Those are the property concerned with the loan affair. But mind you, those are not all of the property owned by Alhaji Baba Danpullo in South Africa. This other huge story building of over 30 floors contains a supermarket. Like the others, it is called Marble Taurus. It is owned by Baba Danpullo but not contained in the liquidation documents. In essence, this property still belongs to Alhaji Baba Danpullo. Next is this other property still under the ownership of Baba Danpullo. The 5th floor of Mandela Square contains another huge supermarket in the heart of Johannesburg. One of the most prominent business sites is owned by Alhaji Baba Danpullo. It doesn't feature as well anywhere in the liquidation document, and as such still belongs to the businessman and is holding the Best Inver company. Same with His Majesty Building in Johannesburg, Waldorf Building in Cape Town, Mitsubishi Head Office, Penthouse in Cape Town, plus other property in Port Elizabeth which are not included in the case file. Highly probable thus that they still belong to the Cameroonian billionaire's real estate, the Bessinver Company Limited. Conclusion: not all property which belonged to Baba Danpullo in South Africa were seized by the FNB Bank over the unpaid loans. Now, what is the FNB saying? The FNB, which is one of the largest banks in South Africa and Africa as a whole, with a capital of over $94 billion and present in at least 20 countries in the world, is the principal accused here by Alhaji Baba Danpullo. And still about the portfolio of the FNB Bank, the most recent edition of the Africa Report magazine classifies the first-ranked Bank of South Africa among Africa's top 300 consolidated banking groups with a total score of 88 and an asset of $417 billion, $658 million US. Upon our arrival at the FNB headquarters in South Africa, it wasn't an easy ride to find our way through the gigantic structure. However, we finally got to the service in charge of communication. Directly, we asked of getting more information from the FNB management on the preoccupations of the Cameroonian billionaire about the alleged unfair seizure and spoliation of his real estate property over unpaid loans. We were told the information on a client's account is private and can't be given out publicly to a third party without the client's consent. After insisting for several days because of the quest to get credible information for our audience across the world, the FNB Chief of Communications sent a reply to one of our several emails informing us of the official stance of the FNB Bank concerning the case filed in by Danpullo against their institution in Cameroon.
First National Bank cannot disclose any information about specific bank accounts due to its confidentiality. The bank's debt collection process comply with the relevant laws governing credit agreements in South Africa. First National Bank further confirms that it is not a party to the court case instituted by the Bessinver in Cameroon.
We also mentioned earlier that other companies in Cameroon which have their headquarters in South Africa or great shares are owned by South Africans are also bearing the brunt of the case between Danpullo and the bank. While Danpullo's lawyers say and insist that these South African companies have links with the FNB, Equinoxe Television made several attempts at getting first to the MTN Group in South Africa. This is the headquarters of the MTN Group in South Africa, situated at Rosaport in Johannesburg. We have had several appointments through phone calls and WhatsApp communications with the head of the Corporate Affairs Department, all in a bid to have a one-to-one interview with her on the stance of the MTN Group about what is happening to MTN Cameroon. We had a phone chat with the Corporate Affairs Officer who, after learning of our preoccupation, directed us to her boss, Danpullo Mtn, who is the head of the Corporate Affairs Department of the MTN Group in South Africa. All our attempts here to get a one-to-one interview were futile. Nonetheless, the head of the Corporate Communication Department of MTN Group sent a reply to our email on the position of the MTN Group. This is the official message from the MTN Group in South Africa on the prejudice the MTN branch in Cameroon is facing.
Following South African Minister of Internal Relations and Cooperation Naledi Pandor's statement expressing concern about the treatment of South African businesses in Cameroon, MTN Group confirms that actions by the court in Cameroon are impacting the group's operation in that country. We confirm with concern that on Friday 9th June 2023, a court in Cameroon ordered MTN Cameroon's banking partners to transfer the company's funds that have been garnished from MTN Cameroon's accounts to the court's escrow account. This is part of a long-running dispute between two parties to which MTN has no relation or dealings in Cameroon. This dispute is between South African Bank and Bessinver Cameroon plc, as well as three other companies based in South Africa, collectively referred to here as Bessinver Group. We understand from media reports that the Bessinver Group has Cameroonian businessman Mr. Madu Baba Danpullo as its promoter. In September 2022, several of MTN Cameroon's banking partners were served the garnishee order on MTN Cameroon's account at the request of Ben Stiller Group. The four companies informed our banking partners that they were seeking to recover the sum of 259.2 billion in a dispute that they supposedly had with the bank based in South Africa, which is completely unrelated to MTN Cameroon. The four companies claim that the South African bank has a common shareholder with MTN Cameroon, which is in fact not the case. They therefore seek their resource on MTN Cameroon in Cameroon on a private commercial matter that they have engaged in South Africa. As MTN Cameroon is in no way linked to this bank nor its shareholders in South Africa, registered as surprise and grave concern with all necessary authorities seeking their support to have this garnishee order lifted. This matter is not only offering MTN Cameroon but also another South African-owned company in Cameroon. It is utterly outstanding that MTN is being brought into this issue, which is one apparently between Mr. Madu Baba Danpullo and First National Bank, said MTN Group Chief Sustainability and Corporate Affairs Officer Nanpala Marofo. From the outset, we have pursued all legal channels to resolve this bizarre situation in which we find ourselves caught up, but to no avail. MTN Cameroon prides itself as being a responsible corporate citizen. MTN Cameroon prides itself on being a responsible corporate citizen and finds the garnishment of its account evidently abusive. MTN Cameroon will continue to use all possible legal means available to address this issue, and it's hopeful that the matter will be fairly resolved by the courts and that justice will prevail. MTN Cameroon would like to assure its customers and partners of the continuity of all services offered to them while we seek to resolve the matters expeditiously. At the end of 2022, MTN Cameroon, in which MTN Group owns 80%, accounted for approximately 4% MTN Group service revenue and 3% of Group EBITDA.
Another company attacked is Tiger Brands. Behind me is Tiger Brands, an affiliate of Shokokam in Cameroon. It is one of the companies greatly negatively affected by the Best Invest company saga. But the communications office of Tiger Brands here in South Africa is crying foul. They say they are in no way connected with the Best Invest company loan or credit affair. Shokokam is into food processing. The company's accounts too have been seized, making the running of the structure really complicated and daunting. We as well made several moves to have an interview with the management of Tiger Brands in South Africa. After many calls and emails, the corporate communications director, Brenna Obeholzer, finally, just like MTN, sent us an official statement from the Tiger Brands in South Africa on the setbacks the seizure or confiscation of the account is causing the enterprise.
A well-known Cameroonian businessman, Mr. Danpullo, has been engaged in a dispute with his bankers, First National Bank, in respect of real estate dealings in South Africa. In a matter totally unrelated to this dispute, Shokokam's bank accounts in Cameroon were illegally frozen in September 2022 pursuant to garnishee orders issued in favor of the Cameroonian businessman by the Court of First Instance. The company has been unreasonably caught in the crossfire of the dispute, which is totally unrelated to our business in Cameroon. The Shokokam business is able to continue operations. However, the frozen bank accounts are putting undue pressure on the liquidity of the business. Any further unsatisfactory outcome from ongoing litigation may significantly impact on Shokokam's ability to continue operations. Issues of this nature will also have a negative impact on shareholder support for the company's plans to invest in growing its business on the continent. Tiger Brands and Shokokam are dealing with the issue through the courts in Cameroon, and the matter remains pending before the courts. The dispute has been brought to the attention of the South African High Commissioner in Cameroon and Dr. Naledi Pandor, South Africa's Minister of Internal Relations and Cooperations. Minister Pandor visited Cameroon early in April 2023 and raised the matter during bilateral discussions.
Baba Danpullo's lawyers, in an interview they accorded local tabloids in Cameroon on June 18, 2023, affirmed that the 22 capacity of Danpullo to repay the loan. They as well insist on what they term spoliation of their client's property.
That the first thing you need to understand is if a property is sold and the property is sold above the money that is recoverable by the creditor, the remainder of the money goes to the owner of the asset, the property, the owner of that property. So if you owe a bank X amount of money, maybe let's say, hypothetically speaking, you owe a bank 200,000, your property is sold at 500,000. The bank will take their 200,000. Administration cost of the liquidation will be taken from that amount, and the remainder of that amount, whether it be 300, whether it be 100,000 or 100 rand, if it's the remainder of what the property was worth, then that value is given to you. Well, they might have not agreed with the plan, thinking that the plan is either going to work, and if they feel that the plan is not going to work, they saw it best that the liquidation process gets underway. They knew very well that, and after a business rescue process would have failed, or any plans would have not yielded the results, the next step would be liquidation. So you go into that process knowing, particularly the business rescue process, you know that if this process fails, then the next step is liquidation. Well, I mean, once this liquidation process started, the only thing that can happen is for you to rescind the order. It's not so much about the appeal, because an appeal has timelines in which you can file an appeal after the court has issued. But after a process of liquidation, the only thing you can do is to rescind the judgment that placed you under liquidation. And if that is rescinded, then try to find a way in which you can reverse the process where each party can be restored into the position that they were before liquidation process. But so far, there is not, for a court to consider that and to do that, it must be based on a very exceptional point.
Several attempts by Equinoxe Television to get to Danpullo's lawyers for a one-to-one interview were futile. However, official documents which we got from credible legal sources indicate clearly that the bank, through the court in South Africa, proposed a rescue plan to the Best Invest Limited to help revive the company, which seemed to be collapsing, especially during the COVID-19 pandemic. A rescue plan which Danpullo, through his company, the Best Invest, rejected. The court was left with no option than to bring liquidators in so the FNB could regain its unpaid loans.
I've taken a bond with ABSA. It's one of the popular banks in South Africa. FNB. You've taken a bond. Normally a bond is about 20 years to pay. Now, depending on what then happens, because then you can take a further loan on top of that loan against the house, either to renew or to renovate the house and do other things and alterations to the house. Now, that might then extend the period, depending on the discussion that you discuss with the bank and the kind of interest rates and so forth. If in the event you are not able to pay, certain things happen first. It might be that you are not able to pay because you're perhaps retrenched or dismissed from work. Now, we have insurance that cover those instances, but most people are not prone to take them. And in the event of retrenchment, your insurance can kick in and cover the debts that would have arisen out of you now not being able to pay as a result of retrenchment. If you don't have those in place, then the bank wants their money. they will then initiate a process of debt collection against you. So they will start first with probably SMS campaigns, where they send you SMSs and they say your bond is in areas and this pay by this period and all that sort. Urgently contact us to make arrangements. You ignore it. They'll send you another one, they'll send you another one, they'll send you another one, then they start calling you. We have this debt, when are you going to settle it? And you say, no, this is the situation, I'm unable to work, and they give you maybe a certain period. If you are not able to settle that amount or discuss a payment arrangement with them, they go then through a process called foreclosure, where they then liquidate the house. They are able to then approach the court and say, court, this person owes us this much, has not been paying for X amount of months. We believe it's only fair that the property is taken. Or first the court will rule in their favor and say, you X owe this the bank this amount, pay them immediately. Because remember, at that time when the bank go through that process, the entire amount becomes immediately due and payable. So they're not going to claim for areas of 5,000 if you owe them 5,000. If the entirety of the debt is 500,000, they're going to claim for the 500,000. It's not the areas. So the entire amount, the agreement is cancelled at that point. Then you owe them the capital amount as is. Then the court say, yes, you owe them, pay them. Then they have a judgment in their favor that directs the court, directs the bank to come after you to claim that money. What they then will do, then they will take that and give it to a sheriff. Sheriff will come and serve you, and you still do not make a payment arrangement, or you default on it, or you can't agree. The bank will then go back to court and say, court, now we are ready to execute. We want to execute against the house. We want to take the house and sell it in public market, in open market.
In a nutshell, Baba Danpullo, FNB, MTN, Tiger Brands are the major actors in the Danpullo FNB affair. However, the issue has gone from being purely a business discord to a diplomatic and sub-regional concern. The tension drew the attention of the governor of the Bank of Central African States, BIAC, Abbas Mahamat Toli. He sent a missive to Cameroon's Minister of Finance, Louis-Paul Mutazi, raising serious concerns as to the investment climate in Cameroon. The BIAC governor was solicited by the Association of Banking Institutions of Cameroon, complaining of the judicial orders accompanied by high daily penalties against several banking institutions aimed at forcing them to transfer to the registry of the Bonanjo Court of First Instance designated receiver of funds confined in the framework of pending precautionary seizure procedures. The BIAC boss's correspondence specifies that the large sums confined under said precautionary seizures are funds registered on mobile money pool accounts belonging to mobile money customers. Under the terms of Article 52 of Regulation 04/18/CEMAC COBAC of December 21, 2018 relating to payment services in CEMAC, those accounts are protected against any recourse from other creditors of the payment institution, including in the event of enforcement proceedings or collective debt settlement opened against the payment institutions. The BIAC boss continued by saying, it therefore appears that the community rules, in particular the regulation mentioned above, or applicable national rules, particularly those governing deposits and consignment in Cameroon, are not respected. Mahamat Toli said he particularly draws the attention of stakeholders in the finance sector to the risks posed by such court decisions on the banking and financial system, given the significant financial stakes which do not have a legal basis. He calls on the courts in Cameroon to contact the Minister of Justice and Keeper of the Seals to make him aware of the rules governing the banking and financial system. The poor application, which could contain the seeds of a systematic risk. Danpullo's lawyers have described the correspondence of the Biya governor as unacceptable, risky, reckless, and contrary to diplomatic norms. The Baba Danpullo loan or credit saga with the First National Bank, which has been dragging along with its collateral like MTN and Tiger Brands or Chococam, is feared might cause further diplomatic rift between Cameroon and South Africa, reason for which diplomatic and legal or judicial negotiations are still going on, hopefully towards a consensual solution respecting the laws of both countries and legal engagement of all the parties concerned. Welcome back, viewers. You just got hard facts there which we gathered on the field when we were in South Africa. We had to meander, you saw it in the video, through courtrooms, get to the headquarters of the discontented enterprises in South Africa so as to get first-hand information. And now, with me in the studio are two legal minds, Barrister Moustaha NGOUANA and Barrister TARLA Jude. Thank you so much for accepting to be our guest today on Equinoxe Television. We begin with you, Barrister Moustaha NGOUANA. Thank you so much for coming.
Thank you, Annabila. Thank you for inviting me. It's a pleasure to be part of your program this evening. I hope we will try to draw the attention for Cameroonian citizens about the key point or the salient point of the situation that's facing, that MTN and Mr. Danpullo are facing, and so that at the end people can really understand what's going on.
Okay, that is one of the reasons we are here. Now we watched the documentary together. What's your take on this legal battle between, as a legal mind, what do you think about this battle between Danpullo, MTN, and even Tiger Brands?
As a legal mind, I think that to be sincere, when you go through the facts, you realize that Mr. Danpullo went to South Africa. He took a loan of about 20 billion francs CFA, and he gave mortgages. And those mortgages, he gave several buildings as mortgage. And he himself, he was the shortee. Yeah. He was a shortee for the reimbursement of the loan taken. There were several obligations that he was to comply, he was to fulfill. One of them was to pay the loan installment on the monthly basis. Monthly basis. The second
400 million per month.
Something like that. The second was to pay all the taxes
involved.
All the taxes involved related to those buildings and also related to the company, because you know that if the company has problems, the problem can affect also the property of the company. Yeah. That was, he was supposed to pay all the taxes, and it was also an obligation for him to tender to the banks, all the financial statement of the audited financial statement of the companies monthly. He had to do all of that, but unfortunately for the facts that I have with me,
he failed to do that.
He failed to do that. Failing to do that, banks gave him the opportunity to find a way, to find a solution.
Yeah, they call it a rescue plan.
No, yes, I know that there was even before the rescue plan.
Okay.
He received several notices. And he gave several promises that he didn't fulfill. He didn't respect it. It's after the series of letters that he received, and he didn't respond even to all the letters that he received. It's after that a rescue plan was set up, because there is in South Africa there is an Insolvency Act of 1936 that governs bankruptcy and liquidation, and according to the said legal framework, they decided now to put in place a rescue plan, giving you the opportunity to try to solve the situation. And the situation is the judiciary that is now taking charge of everything. And he came during that process himself. He gave several promises that he never respected, and they decided now to start attaching his property because at least 4 of his buildings were mortgaged in order to guarantee the loan he took. Unfortunately, he did not respect. Unfortunately, when the bank started, he came with an affidavit that he was owing the bank about 150 million rand. That is the equivalent of 5 billion CFA. Yeah. 5 billion CFA that he was owing the bankers. The bankers now, he came with the affidavit, and he pretends that he was expecting money from another bank in order to come and pay the said amount. Unfortunately, he did not respect that also. That's why the bank was finally obliged to continue with the liquidation process that's coming immediately after the rescue plan proposed to him.
Okay, Barrister. Now, this other question. We know that the businessman Baba Danpullo came to complain in Cameroon. We watched it in the documentary. That was after, you mentioned it too, that was after his assets were seized by the First National Bank. He came back to his country, which is Cameroon, and complained. And now Cameroon, on its part now, took on MTN and Tiger Brands, right? Is there no legal basis? Because logically, that seems correct.
No, you can. There is retaliation is not justice. That's something that need to be highlighted. Retaliation is not justice. And moreover, the company that came to Cameroon has no legal personality, because you have to understand something, that when the company is under liquidation, the company has personality. Sure. Now is the liquidator who can act on your behalf. That means normally
the liquidator stands between you and the creditor.
Yes, it stands between you and the creditor. He's the one who is representing, who is the one who is answerable to any other things.
Yeah, because the liquidator is neutral.
He is neutral, and now his job is to try to sell the asset, to compensate the bank,
so that both parties are satisfied.
Are satisfied. You understand? Now, unfortunately, I want to think that no matter the fact that I'm a Cameroonian, that what is happening today in our country is a shame. It's a shame because we are giving a very bad sign of our justice. It's just like what happened a few days back with the judge at the military tribunal who took a decision, and the same day he said that he's not the one who took the same decision. You have to understand something that is that the South African judicial system is a very strong judicial system. What's happening here in Cameroon is that
it's completely independent from what we got on the field.
It is completely independent. You cannot compare the South African judicial system with the system in Cameroon. They now came in Cameroon, they are attaching the property of MTN, alleging that
MTN has connections.
MTN has connections with First Rand Bank. As a legal man, it is not possible that such a thing happened, because even if MTN Cameroon was a subsidiary of MTN South Africa, such a thing cannot happen, because the subsidiary cannot be liable of the debts of the parent company. It's not possible. And moreover, when you dig a bit, you will realize that South Africa, MTN Cameroon, do not have MTN South Africa as a shareholder. It's MTN Mauritius and some Cameroonians who are the partners or the shareholders of MTN Cameroon.
But Barrister, we just heard MTN, the MTN group in South Africa reacting and saying that it's causing them some prejudice that have been affected too negatively by the freezing of MTN accounts in Cameroon. You know that they have an economic interconnection. Yeah, okay.
But legally, they have no connection. You understand? You cannot go because you are the creditor of MTN Cameroon. You will go and seize any other MTN that exists in the world. It's not possible. But economically, they are interconnected. They are connected. They are dependent. They are dependent economically, but they are legally independent. Each of the company has its moral personality. You cannot go and attach the property of one of the company because of the debts of the others. They are completely independent in their management.
So the problem now is our judicial system, because as we speak, MTN is suffering.
As you are saying, as I was saying, is a shame for our judicial system, because this is causing us untold hardship. Because you know that the sovereign rating of our country, that means the opinion that the opinion creditors has of our country is very bad. That will make us, maybe tomorrow, if we want to go and borrow money anywhere in the world, the interest will be very high, because our country is not a country where you can trust the judicial system. While willing to help a Cameroonian citizen, what they are doing is worse than leaving the said citizen even losing the company or losing one or two buildings in South Africa. And
just to mention that the accounts, like what MTN says, is owned by subscribers of mobile money. It's not owned by an entire MTN, which means that the subscribers might be in difficulties. I
read the letter sent by the governor of Beak to the Minister of Finance of Cameroon, reproaching the fact that our judicial system is accepting that they attach the money of consumers Cameroonian consumers who have no link with the enterprises. That's something that is really I'm very flabbergasted when I see such a situation, and we are continuously aggravating the situation of our country, because it will be very difficult for an investor to come in such a country where somebody can come and attach the property of another company with no base. Because what you have to understand is, according to the Article 54 and 55 of OADA law on recovery and enforcement measure, you should have a well-founded claim.
Before you can tamper with somebody's money, you can
freeze the account, or you can attach the account of such a person. So, unfortunately, there is no link between MTN Cameroon and Mr. Danpullo, or with First Rand Bank, as those people are alleging. That's why I'm saying it's allegation.
But I was about coming to that question, because Danpullo's lawyers are claiming that MTN and Tiger Brands, because there are some other companies which have not been touched, which have their headquarters in South Africa, so to speak. They say that they have a relationship, MTN and Tiger Brands, right, connecting it with the First Rand Bank. That is why, according to Danpullo's lawyers, who actually refused granting us an interview because we would have loved to have them explain this to us better, they say that to them, the seizure of MTN's account and Tiger Brands is to force South Africans, or South Africa as a whole, and the First National Bank, which is in South Africa, to release the confiscated property of Danpullo. Don't you think they can't be doing that for nothing? There should be, according to them, they claim there should be a relationship somehow.
The only fact that my colleagues are refusing to come and discuss with you is the gospel proof, a gospel truth, or the fact that they have no case. They have no case because you cannot claim the fact that there is a link because First Rand Bank in South Africa may have an interest in MTN South Africa, not even MTN Cameroon, and you take it as a grant to come and attach the property of another company in Cameroon. Legally, is not possible, and I'm sure of something. If these matters arrive at the Common Court of Justice and Arbitration in Ivory Coast, all of them will be quashed. We are sure of that.
Okay, Barrister, what we went to South Africa because we needed to get correct, concise information about what happened. Everybody else watched. That is what we gathered on the field. We didn't add or reduce anything. What, according to you, because nobody wants war. What we want is this thing to be resolved cordially. What, according to you, should be done to ensure that MTN gets back what they are due, and for the justice system in Cameroon to understand that it's not because you're a Cameroonian and then you're a Cameroonian out of Cameroon and then you come to Cameroon and complain, and a business person or enterprise is seized and frozen, caring less about the consequences. Because Danpullo's lawyers are talking about xenophobia. What should be done as a legal man? What do you propose?
First of all, I cannot think that there is xenophobia because there are many Cameroonians who have invested in South Africa. Late Moncam, For You, and many other Cameroonians have invested there. And I think all the assets of Mr. Danpullo have not been attached. Sure. If there was xenophobia, I think they will have attached everything, and not only his asset, but the asset of only other people living in South Africa. That's not the reason. When you are saying that what MTN has to do, MTN has to do nothing. The judicial system has to apply the law. And there is no law who give authority to our judges to attach the property of a third party who didn't have any link with the creditor, the person who is claiming himself as the creditor. Nothing to do. The only thing to do is for the judicial system to recover his coal mine and respect the law. What you have to do is, as if you are in your house, somebody come and say that everything inside belongs to him. Yes. What you have to do, the justice has to say that, no, what you are saying is not right, because MTN has all document evidence in the fact that the money, maybe the money who has been frozen belong to consumers or belong to MTN. Mm-hmm. You cannot ask me to. That's why you call in law probatio diabolica. You cannot ask me to prove something that does not exist. It's not possible. You understand? For now, the only thing to be done by the judicial system is to release the accounts of MTN. If something had to be done, when the rescue plan was proposed to Mr. Danpullo, he would have respected it. Moreover, during the rescue plan, they asked him in South Africa that give us a proxy to sell some of the assets, so that we can continue with the reimbursement of the loan. Unfortunately, he refused. That's where he came with the affidavit. And when you say an affidavit, then you are taking oath. Yeah. You are taking oath, and he did not respect.
You are consenting.
You are consenting, and he did not respect the oath he took.
Okay. Yes. Okay, Barrister. We just want. Nobody wants a diplomatic rift or tension between Cameroon and South Africa. That is why we had to go on the field, despite all what it had to cost us, to ensure that we get the right information for the public to know what is happening and for the right solution to be sought to this problem. The saga between Danpullo Mtn, Tiger Brands too, which is also affected, and also the FNB in South Africa. Thank you, Barrister, for coming. We would surely be talking about this maybe some other time. And like I announced a while ago, we have Barrister Jude, who is also a legal mind. Thank you, Barrister, for coming.
Thank you for inviting me. I hope you have another occasion. It's the first time for me to come to this your program. I hope you have another occasion. Thank you once more.
Sure, we will, especially until we have a cordial, a lasting solution to the MTN crisis.
Thank you.
Welcome back, viewers. Welcome, Barrister TARLA Jude. Thank you so much for having you. Now, I want to find out from you. We just watched the documentary together. You were here, and Danpullo and his lawyers are complaining that the Cameroonian South African judiciary was somehow biased, because they say their property, which is worth over 250 billion francs CFA, cannot be auctioned or liquidated over a loan which is worth just 22 billion francs CFA, according to the documents we got in South Africa. There, Danpullo can have a reason, don't you think so, as a legal mind?
Well, it's a strong allegation to say the courts were biased. Why would I say so? Procedures in court follow the law. And in every judicial system, there is a procedure for liquidation. Before you get into mortgage, you have to get through the notarial act from the notary. It follows a procedure, and all of them are enshrined in the law. Now, this is what happened. You provide security, which guarantees your loan. And in the event wherein you cannot respect the terms of your engagement of your mortgage agreement, then there is foreclosure, and that is what the law says. There will be a foreclosure based on the fact that maybe there is no repayment of your loan, maybe breach of certain terms of the contract. I'm sure that for this particular case, we had Danpullo's loan was rescheduled about 4 times.
Yeah, and he had been taking loans from the First National Bank and he refunded without any problem. But this one seems to be having a lot of difficulties.
Yes, the reason is that once you take a loan, you have to repay. If you don't repay, whatever you had provided as security, it is going to move to the next stage of the proceedings, which is going to be foreclosure and maybe auction. And that is the procedure. The law is clear on that. It has given provisions for people to take loans and for a means to either ensure that money from the banks are not loosed or money from the banks should be recovered one way or another. The law is there to protect everyone, be it the person who comes in for the loan and the bankers. There is no way someone will come to say and hold that the courts were biased. If the courts are biased, there are other legal means you can take to challenge the decision, because if you're not satisfied with a decision from a court, you have the appellate courts wherein you can resort for other remedies so that the decisions from the lower court be squashed. So in this case, I think that following the facts on the ground, the houses that were mortgaged and the loans that were not paid and the restructuring of the loans that were done and the plans that were put in place for the payment of the loan that were not met up with, give the courts reasons to order for mortgage and for liquidation.
But now, Barrister Jude, here in Cameroon, the Bonanjo Court of First Instance has frozen the accounts of MTN because Danpullo also complained. Just like in South Africa, the courts, through the liquidators, allowed for Danpullo's assets to be liquidated in South Africa over his unpaid loans. Are you trying to say that the courts in Cameroon are not independent? Because they are courts, they are all tribunals.
Well, I would not want to say that the courts in Cameroon are not independent. Somehow they are, and somehow we know that with some
maneuvers,
we could, in some instances, they might not be that independent. When we talk about the independence of the court, what do we mean? It means that the judge can take free decisions with his conscience and the law, and based on that only, not by external influences. Now, we have to look at the facts of the case to understand certain things. What are the bases for which the courts in Cameroon ordered for the attachment? That's the first question we have to answer. Were they well-grounded facts on which the courts could rely to arrive at the said decision? For example, we know that at law, you must have a connect between two parties before you can arrive a good judgment. Now, what do I mean by that? There should be a nexus. There must be a link between the person bringing an application before the court and the person from which he is seeking redress. Once you don't have that connect, there is no way, there is no magic that a judge is going to arrive at a decision saying that you should pay X with whom you have no connection. Totally, I think it's outrageous to arrive at a decision that you should pay B with whom you had no business with. If I need to pay Y, we should have something in common. We should have a business, and he must have an interest. And that's where the law, you begin to know that what you file in court. Because if we say there is a company in South Africa, for example, that was under liquidation, and they come to seize the court in Cameroon, and here it is not even represented by the liquidator. we start doubting whether the right parties were in court. Because a company under liquidation has liquidators that have been appointed. Those liquidators are the people that have the local standing to bring any action. So an individual who is not a liquidator, it is going to beat my imagination if a judge, a right-sounding judge or thinking judge, who proceed to give a judgment on someone who lacks capacity to bring an action against another person.
Barrister, now, we just said something there. Because when we went in South Africa, we went to the FNB, and they told us that is the bank concerned in this loan affair. They told us that they are not even aware of the case which has been filed in by Danpullo and his lawyers in Cameroon. Now, I want to find out from you, you're a lawyer, a legal mind. Is that possible that a judgment is passed until the account of an entire enterprise or two are frozen without the consent party on the other side present in court?
That is why I started off by saying that there must be a nexus for a judge to enter a judgment against the parties. Without a connect, there is nothing tying two persons and you bring a judgment that binds them together. I think it's fundamentally wrong. I will try to elucidate some stuffs here now, some legal arguments. You see, at law we have what they call the principle of lifting the veil. When we look at companies, corporate personalities of companies, you understand that each has a separate identity. Yeah. And upon carrying certain acts, we even need to the courts have to determine, they have to lift up the veil of incorporation to see who is behind that veil. In a case where you cannot even lift up the veil to see that the people behind the company have no nexus with you and you proceed in arriving at a decision, I think is fundamentally wrong. If we continue like that, then the legal system, I think, will carry us nowhere. We will not have investors coming in Cameroon because we will not follow due processes. It is clear any establishment, corporate establishment, is unique. It is separate. It is identical. You cannot take Y for X, and you cannot take the loans or the sins of one party or of another person to visit on another person. It doesn't work at law. If Y is identified as a party to a suit and you have an interest, you come to court in your favor, knowing that you have an interest. There is no way you can come to a court, you don't have an interest in a matter, and you are seeking for some redress and for some solutions from that court.
Yeah, Barrister, it's true that the Danpullo's lawyers are claiming that there is a relationship somehow. MTN on their part are saying that we don't have any relationship. So you see, there is a lot of controversy and war of words, let me put it that way. But like you said, they should be clear, it should be evident, the relationship between the both parties for the court to be able to judge fairly. Yeah. Now, we don't have enough time, Barrister. I was talking a while ago with Barrister NGOUANA. We, as a legal mind, because where we stand, the case is still in court, is still pending. Meantime, mobile money subscribers of MTN should be suffering. What should be done and how soon for this thing to be resolved cordially, so it doesn't lead us to a diplomatic affair between the two countries?
Well, if you say it doesn't lead us into a diplomatic situation, I guess that we are already there. But again, the courts are supposed to protect the interests of each individual in the country. MTN mobile money subscribers with their monies in MTN should be protected. I think it is it would be sheer madness for a court to just order that the money that Y or X have in their accounts with MTN should be transferred to another, to some other place because they have issues with Y or Z. It doesn't work that way. If not, then it means that the normal, ordinary citizens in Cameroon will not be protected. And I don't think that the laws should be made in such a way that the fellow citizens in Cameroon are not protected. MTN does not own all the money that the courts might just order, that pay this particular amount into the registry of the courts without identifying specifically who owns what. Yeah. And why they are paying. You cannot take money of mobile money subscribers and you are paying into the court. It's going to frustrate the businesses of a company that is running here and providing services for us. You can imagine if we go for maybe for months without being able to communicate, because
transactions, yeah.
Not only transactions, because financials is just one, communicating. Yeah. I mean, it is going to cause a lot of problems. And in the world of today that we know, it's a world of technology, it is sheer madness to think that communication can be blocked because someone who claims he has a right comes to say, okay, block the account. I don't think it's done that way.
Okay, but just to mention too that it's not just MTN, there is also Tiger Brands that has also been crying foul because their accounts too have been frozen. Tiger Brands is, let's say, Chococam in Cameroon. They have huge businesses which are somehow blocked now because their accounts, following the complaints of Danpullo, have been frozen in Cameroon after instructions by the Bonanjo Court of First Instance. Barrister, thank you so much for coming and hope to have you some other time. That is, maybe we'll be talking about other legal issues.
Thank you, thank you, thank you.
And viewers, thank you so much for watching.